Hi. Another interesting judgment of Bombay High Court. Vedanta Limited versus Profess International Private Limited. That is the case. Here, the question of appointment of arbitrator after the period of limitation is over arose before the Bombay High Court. Briefly, the facts are Vedanta Limited is referred to as VL and Profess International Limited is referred to as PIPL for easy. Otherwise, again and again, I have to say Vedanta Limited, Profess International Limited. So, BL entered into a contract with PIPL. Time was the essence of contract. PIPL failed to perform the contract. So, naturally, VL issued a notice for termination. The petitioner, we will say. The respondent, PIPL, accepted its mistake and asked for extension. That was also granted. But still, it did not complete the work. Another agency was appointed to complete the project, and the project was completed. Now, VL, the petitioner, issued a notice for the costs and other charges to the tune of 4 crores. The respondent, PIPL, remained silent. VL took all these steps to amicably settle the issue, but no response from the respondent. So, VL invoked the arbitration clause. It filed an application under Section 11 of ANC Act before Bombay High Court for appointment of arbitrator. The contention of the respondent PIPL was the cause of action arose on 8/12/2018 when the notice of termination was issued. The period of 3 years got over by December 2021. So now the time limit is only 3 years. Since 3 years have lapsed, then the application requesting for appointment of arbitrator cannot be entertained. That was the argument before the Bombay High Court by the respondent PIPL. Bombay High Court refused to accept that the triggering point was 8/12/2018. Arbitration clause did not simply provide for arbitration. Some important dates were noticed by the Bombay High Court. The notice for termination was issued on 22/5/2019. These are all very important dates. Notice of dispute after COVID period was issued on 19/9/2022. On 1/12/22, notice for mediation was issued. Subsequently, notice for arbitration was issued on 11/1/2023. So, Bombay High Court relied on a Supreme Court judgment which observed that limitation for arbitration and cause of action to appoint an arbitrator would commence from the breaking point at which any reasonable party would abandon the efforts for arriving at a settlement and contemplated referral of the dispute to arbitration. This is very, very important. What is the breaking point? When is the cause of action arises? According to Supreme Court, the cause of action to appoint an arbitrator would commence from the breaking point at which any reasonable party would abandon the efforts for arriving at a settlement and contemplated referral of the dispute to arbitration. Such a breaking point should be treated as a date on which cause of action arose. Subsequent negotiations, if any, between the parties which took place after the cause of action has arisen would not postpone cause of action for the purpose of limitation. That is the view of the Supreme Court. Bombay High Court held in the present case the aspect of limitation is a mixed question of fact and law and cannot be gone into while deciding the application for appointment of arbitrator. The High Court relied on another judgment which opined that only in rare and exceptional cases where the claim is ex facie time barred or hopelessly time barred, the appointment of arbitrator can be refused. While the limitation period for filing a petition seeking appointment of arbitrator or reference or dispute to the arbitration is to be examined by the court. The limitation of the substantive claim is to be looked into by the arbitrary tribunal. Arbitral tribunal, and not by the court. The only exception is when the claim is hopelessly barred by limitation, and this should be apparent from the admitted facts and documents. So Bombay High Court appointed the arbitrator. It said, no, no, at this stage, we will not enter into the question of whether the claim is that substantive claim is time barred or not. Let the tribunal, arbitral tribunal, decide that issue. We will appoint the arbitrator, and hence it appointed the arbitrator. So the one important point to be taken note of is sometimes there are many intelligent people in many corporates. They will just in the name of negotiation, they will go on dragging the issue. But you have to note down which is the breaking point so that you don't fall in the clause of absolutely time barred clause. That is what my opinion is. Thank you very much. Have a great day. Bye.